Your medical malpractice case is coming up for trial. What happens if we don't notify our opponents that we have a medical expert who's going to be coming in and testifying in support of your case? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So here's the scenario. If we go ahead to trial and now I try and bring in a medical expert to support your claim, but I have failed to notify my opponent in a timely fashion that we are bringing in a medical expert to support your claim and to tell them about our witness's credentials as well as what they're going to be talking about, here's what's going to happen. Your Honor, I call Dr. Expert to the stand. Objection, says the defense attorney. And now the judge asks the defense attorney, what's the objection? We have no idea who this witness is. Mr. Oginski has failed to tell us what this expert's credentials are, nor do we even know what this expert is going to be testifying about. Mr. Oginski has failed to notify us in a timely fashion, as he's required to do here in New York, about which experts they're going to be bringing in and what they're going to be testifying about. Then the judge is going to be turning to me and say, Mr. Oginski, what do you have to say about that? And the only real valid explanation that I could provide to the judge at that time would be, Your Honor, we were unable to get a medical expert up until a few days before trial. And as soon as we retained this particular expert, I immediately notified my adversary, told him the qualifications, and told him what this expert would be testifying about. Now, it is questionable as to whether or not the judge will allow that witness to testify based upon that explanation. In New York, we are obligated to notify our opponents of the medical experts that we are bringing in to support our particular claim. They have to be able to prepare for cross-examination. They are entitled to learn what the expert's qualifications are, as well as the substance of what they're going to be talking about. If we don't bring in medical experts to support your particular claim in a medical malpractice case, what will happen is that when we rest, when we tell the judge that we are done with all of our witnesses, the defense is going to get up and jump up and say, Your Honor, I move for summary judgment. I want this case dismissed. Mr. Oginski has failed to bring in the necessary experts to support his particular claim. And if we have not been able to, and the judge has prevented us from allowing our witnesses to testify, then what he'll do is he will dismiss the case. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what occurs in the litigation process in the state of New York in a medical malpractice case. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. What I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.